Welcome back to Courtroom Authority. Today's case is already loaded with drama. We've got defendant Alicia Cargill charged with a serious felony, assault with intent to do great bodily harm. Right out of the gate, you'll notice the tension. The defense attorney explains multiple failed attempts to meet with her in prison, and Alicia immediately fires back, accusing him of lying about showing up late. Viewers, pay attention here. This isn't just a minor scheduling dispute. These moments often reveal whether there's trust between client and attorney, and clearly, that trust is broken. Now, Alicia makes a shocking declaration. She doesn't even want an attorney. Imagine facing a potential 10-year prison sentence and deciding to go it alone. What do you think? Is this a bold stand for independence or a dangerous gamble? Stick with us because the judge is about to issue a reality check.
Court does call the case People versus Alicia Cargill.
Good morning, Rob J. Cohen. Cargill. Cargill, would you state your name for the record? Judge, while we're waiting, just a brief history. I did see Ms. Cargill at the prison on August 20th. On September 12th and September 19th, I went to the prison. They could not find a computer to play the disc. They finally found one and called me. I went yesterday to see Ms. Cargill to play the disc. She refused to see me. So I'm not sure where we are in this matter, Judge.
State your name, please.
Alicia Cargill.
Thank you. All right. What would you like me to do with this matter?
Ms. Cargill, if I come out to see you to play the video, are you going to see me?
At this point, I don't want an attorney.
You what?
I do not want an attorney. You're stating
At
things
all?
that are not true. You came up here and you were how late? So yeah, I was no longer at control center an hour after the time that was scheduled. You're right. But it's not that I refused to see you. I sat up here for an hour yesterday. You did not show up. You were late. Extremely
Cargill,
late. So miss me with that. I don't want no
hold on.
attorney. I represent myself.
Ms. Cargill, hold on. So is it right now that you don't want an attorney at all? Or
Yeah, at this point, I can represent myself. He still hasn't sent me my discovery. He came out here over a month ago. I asked for a discovery. I'm yet to receive any paperwork about this case at all. I don't know anything that's going on.
okay, so you want to represent yourself?
Yes.
Okay, I'd have to advise you that might not be advisable to represent yourself in this case. You are charged with the offense of assault with intent to do great bodily harm less than murder or by strangulation. That is a felony punishable by up to 10 years incarceration and or a $5,000 fine plus court costs. Do you understand all of that?
No, because when I got arraigned, that's not what I was charged with.
You understand also that if you do represent yourself, you will be held to the same standards as any attorney, that the court will not be assisting you in any way in your representation. You understand that, sir?
I do not want this attorney. So it doesn't, at the end of the day, and then you're sitting here you're telling me new charges that's not what I was arraigned under. I was arraigned under assault or whatever with less than whatever. Nothing with strangulation.
Sir,
this is news.
Ma'am,
so I'm confused.
That's the charge that I have before me. That's why I'm apprising you of what the charges are. You wish to represent yourself. I told you that you will be held to the same standards. The court would also indicate that if at some time you wish to be to have the representation of counsel, you need to just request that of the court, and the court will oblige and make sure that you are represented by counsel. Do you understand all of that?
I understand everything you're saying.
Okay. What do you wish for me to do today? Adjourn the matter so you can get discovery, or what do you want me to do?
I mean, I want my discovery I'm entitled to. I want to be represented properly if I'm going to be represented. I don't want to hear, I don't understand. So,
you want me to adjourn the matter out so that you can get all that information and make your decision, or what do you want me to do?
I can't go in the breakout room with my attorney or anything. I'm confused. I don't get this.
I am not gonna do that, sir, ma'am.
Okay, well, I'm not I didn't consent to Zoom either, so I don't know what's going on.
Judge, I'm just for the record, never mind. I'm not trying to get into argument. We went over the discovery. I was 10 minutes late yesterday. They could not find a computer to play my disc. That was the delay, Mr. Cargill. Now, I sat there for close to 45 minutes before they told me they had a computer to play your disc.
Well, I think you need to get the discovery to the person. I am going to find good cause to adjourn this proceeding since nobody will give me an answer of what they want to do. I will adjourn it 2 weeks out. I need 2 weeks for the writ in any event. So it's going to have to be October 16th, that following Thursday from the Tuesday. October 16th, 2025, 9 a.m. Bond continued. Thank you.
I'm sorry, I'm on vacation.
Well, wants to represent himself. I don't know what you guys are going to do. I'm setting it for that date. You can talk to each other, make your decision. If it looks like you are going to be representing this individual, Mr. Killowald, then certainly you can seek an adjournment from the prosecutor to set a date. Thank you.
And here's where the courtroom confusion reaches a boiling point. Alicia insists she never got her discovery, the very documents that lay out the evidence against her, while her attorney claims he went over it already. On top of that, she's frustrated about being forced into a Zoom hearing, saying she never consented. The judge, clearly fed up with the back and forth, does the only thing he can: adjourns the case for 2 more weeks. This isn't just about delay, it's about giving both sides time to sort out whether Alicia will represent herself or stick with her attorney. Now here's the legal takeaway. When a defendant chooses self-representation, it's called pro se representation. Judges almost always warn against it because defendants are held to the exact same standards as trained lawyers. That means no leniency for mistakes. One slip could change the outcome of the trial. So what's your verdict on Alicia's decision? Was she standing up for her rights or setting herself up for failure? Drop your thoughts in the comments. We read them all. And if you found this breakdown as eye-opening as we did, make sure to like this video, share it with your friends, and subscribe to Courtroom Authority for more jaw-dropping courtroom drama. Until next time, stay sharp and stay tuned.